Easements are rights to use or cross another's land for specific purposes. They often involve a dominant estate as the property with an easement over the servient estate. However, for an easement that doesn't run with any particular dominant estate, the right belongs to a person or entity rather than a parcel of land. This is called an easement in gross. In the 1984 Utah matter of Crane versus Crane, we examined some characteristics of such easements. In 1947, 30,000 acres of Fishlake National Forest were designated for grazing cattle. This area was called the Water Hollow C&H Allotment. The following year, Elliot and Wanda Crane bought nearly 2,000 acres of land adjacent to the National Forest. 12 cattle owners, including Clayton Crane, held permits to graze their cattle on the allotment. They hired riders to move the cattle to the allotment each spring and bring them back in the fall. For both directions, they used a 5-mile dirt road that crossed Elliot and Wanda Crane's land for 2 miles. The cattle owners got their permits from predecessors who had been driving cattle on that road since 1950. At some point, tensions mounted between Elliot and the cattle owners regarding use of the road. As a result, the cattle owners sought to establish in court that an easement by prescription to drive the cattle to and from the allotment through Elliot and Wanda's land existed. The court agreed and decreed the easement. Elliot and Wanda appealed, contending the requirements for an easement by prescription weren't satisfied.